This Week in the Boardroom, brought to you by corporate board member and host NYSE Euronext, along with governance knowledge partner Paul Weiss and contributing partners National Investor Relations Institute and the Society of Corporate Secretaries and Governance Professionals.
Welcome to this special edition of This Week in the Boardroom. I'm TK Kerstetter with Corporate Board Member, and I'm joined by Scott Cutler, the Executive Vice President for NYSE Euronext. Welcome, Scott. Here we are again, our second remote that we're doing from the annual Boardroom Summit. It's a great place for us to hold the show because we have such great guests as witnessed today. And it's my pleasure to welcome William Chandler, who's the former Chancellor of the Delaware Court of Chancery. Welcome, Bill.
Thank you.
We're going to talk a little bit about the issues that may have crossed your path in your career. And first, let me congratulate you on a great career on the bench and welcome you to what I might categorize as the dark side. Okay, you're on the other side. Throughout your career, you've got to interact with hundreds of directors and companies on all kinds of issues. So I think it might be good if we start, since you have all those years of experience, if we look at what concerns you most, sort of about the current trends in the boardroom, and what gives you hope, you know, when you look at sort of the growing public sentiment, which right now isn't good, but you know, what sort of gives you hope, because there's a long history of this stuff sort of working itself out?
Well, I'm happy to do that, TK. Going back to your reference to the dark side, though, I think that the way I'm looking at my new role is sort of, to use a sports metaphor or sports analogy, whereas before I was calling balls and strikes, now I'm actually helping to coach or manage in a way to help those who are on the field playing avoid getting called out or to be able to be called safe. So that's kind of the way I look at it as a sports change of position a little bit, but it's very similar to what I've been doing for the past 25 years, and 22 of which were on the Court of Chancery. But in reference to your question, I really have thought about this a lot, and to me, directors are just doing an amazing job, and I saw it day in and day out in the work of the court. Even though directors were the objects of lawsuits, I saw a lot of directors in that capacity in various ways. And I also speak to directors and did speak to directors frequently at directors' colleges. And they have a lot on their plate. And they're trying to do a lot that they're obligated and required to do with all the new requirements that come down, principally from the federal government. And so my real concern as I watch this unfold, and as I talk to so many directors, is how much pressure are we putting on them to do increasingly more things? And it, unfortunately, I think sometimes can create a sort of check-the-box mentality, and that worries me because I'm afraid that it deflects them from what I'd like them to be spending lots of time on, which is thinking about the business model, the business strategy of the company. What are our growth trajectories? What are better ways that we could perhaps be steering the company in the future? That's the sort of business acumen that they bring to the board. I'm just worried that they aren't getting enough time to actually deliver on that because of all of the other distractions and requirements that they're faced with. And so that's my concern. But I think the good news, after all those years on the bench and seeing directors in a lot of different situations that they didn't want to be in, you could count on one hand the number of times where a director in Delaware in the courts was found responsible for having engaged in wrongdoing or having in some way violated some fiduciary duty. On one hand, in 22 years, that's not very many. So the risk of liability, I think, is extraordinarily low. The risk of litigation, on the other hand, is extraordinarily high. We live in a litigious society, and so litigation happens all the time. And in my view, they need to be prepared to deal with litigation because that's a feature of the life of a director these days. And so that's sort of where my new role is coming into play, where I'm trying to give advice before something happens to try to avoid problems. And then if they have already encountered the problem, what's the best way to get out of it?
I think we would all agree that the fundamental objective of a board should be on long-term value creation. But one of the challenges that many boards face today is in the face of, call it short-termism, or maybe even a different view of institutional investors about the current direction that a company could be in, maybe motivated by short-term results. What is your advice to directors that may have a different long-term view about what's in the best interest of shareholders in light of a different or maybe even opposition from maybe the advisors or institutional shareholders about saying they should be doing something different in the short term?
Well, the advice or the commentary that I would give them is that, first, Delaware law has been absolutely consistent, I think, on this. And that is we don't distinguish amongst or between stockholders or their varying interests. Number one, they're all treated equally. And secondly, and even more importantly, Delaware law has always emphasized the importance of the long-term best interests of the corporation and all of its shareholders. So that's been the emphasis of Delaware law. And so when I talk to directors who mention this, increasing pressure they get from whether it's hedge funds, activist shareholders, arbitrageurs, whatever the case may be, I try to encourage them to push back against that sort of pressure and to emphasize that their real object, their real goal is to manage and get management focused on the long-term performance of the company. They have long-term shareholders, and those are the folks like myself who have 401k plans that are worried about their grandchildren and their future retirements. They're not worried about the next quarter's results necessarily. They're not worried about tomorrow's stock price. They're not worried about whether or not you could easily liquidate an asset and get a lot of money that you could then get out and distribute. They're worried, I'm worried about the long-term health and future of the company and the returns that that's going to generate. This shows up, frequently, I think, in the compensation area, because there you're trying to manage the company in a way where you're matching the pay for long-term performance, not immediate performance. And so I tell directors frequently, think about how you can align the incentives of management with that long-term objective and not the short term. How can you design compensation packages that demonstrate that that's what you're really worried about, is the long-term growth cycle and not the immediate short-term gains? So there are a lot of ways that I think directors are. You're absolutely right. It's not an easy thing. It's easy for me to sit here and say, but it's not easy to push back against those pressures, but it's really important that they push back against them. I mean, short-term, capital is impatient. And it's the most impatient capital is often the loudest capital. They got the loudest voices. And so I know that exerts tremendous pressure on directors. But I think my advice is resist that pressure, stay focused on the long term, build your compensation package along that same way, and you'll be all right.
Scott, I like that phrase, capital is impatient.
Yeah.
I'll have to remember that. That's very, very real. But Bill, this morning we heard in the conference sort of frustration around the non-binding mandated say-on pay and really the lawsuits by the plaintiffs' bar that has originated. Now, arguably, there's only 8 out of a whole lot of companies, but here's situations where most of the experts that I've talked to, when you read what the regs were around that, consider these sort of frivolous, lawsuits. The plaintiff's bar has saw an opportunity to generate revenue. Okay, do you sit there and this would be my thought process. I sit there and almost wish that companies would fight this. Okay, because I think if it ends up in any type of court situation, it's going to be quickly, put aside, and because when you settle, it just seems like we're promoting, with the next run of things, that this 8 will turn to 20 or 30 because it's creating an opportunity, on that side. Do you ever think to yourself, geez, I wish that was a case that would end up because we can sort of, take this on and get this frivolous in our past and stop this distraction?
Well, I have to confess it does cross my mind, and I have sort of secretly wished and say a little prayer every night, in fact, that someone will hire me to fight this, and I'd love, most of all, to fight it in the Delaware courts, in the Delaware Court of Chancery and Supreme Court, because I think fundamentally, in most of these instances, it raises an issue of Delaware corporate law. These are usually Delaware companies. Many of the ones that have been sued are Delaware corporations. Under the internal affairs doctrine, They're governed by Delaware law. This involves a classic issue between shareholders and managers. It's a question the Delaware courts should answer and ought to answer, and hopefully they will get to answer it. Until then, you have to pick your battles where they're lodged against you, and a number of companies have settled these cases. A number are now defending. They're filing answers and motions to dismiss. In one case out in Ohio, the motion to dismiss was denied, and so that case is going to move on. It's governed by Ohio law in that case, not Delaware law in that particular instance. But I know there's a lot of frustration about it. My own personal view is that we'll get an answer, and when this is finally resolved, the answer will be that by virtue of a negative vote on a say-on-pay proposal, that is not a breach of a fiduciary duty by directors in having approved the compensation, recommended it, or failing then to reverse it or rescind it after the negative vote. It is simply what it is. It's an advisory vote. If we hold otherwise, then every advisory vote can lead to a lawsuit on every proposal that comes before shareholders at a meeting. That would mean that we have now advisory votes that really are governing instruments in the corporate structure, which makes absolutely no sense to me at all. So I'm hopeful we'll get that challenge eventually heard by the Delaware courts and get an answer.
Let me give you a crystal ball question. When you look at governance and the pendulum swing, over the last few years we've seen an encroachment of federal regulation into the area of governance. Mm-hmm. And you've seen a massive shift, I think, towards a lot more importance placed on ISS and other advisory firms than maybe had been in the past. Where are we going with governance? What is the challenge, and where do you see this going?
Well, my experience is these things tend to function like a pendulum. They have their swings, and so we may be in one of those swings at the moment where there is an increasing amount, has been an increasing amount of emphasis on federal responses to these governance issues and the governance crises that came out of the subprime or earlier with the Enron WorldCom affair. And that's not unexpected. It's happened before, and it probably will happen again. I'm hoping we don't have another episode like we had in 2007, 2009. But if it does, to me, it requires a modulation between the states and the federal government. I'm one of those who thinks that we can work out a modus vivendi where the feds won't increasingly intrude onto the state's province of deciding basic corporate law and the relations between shareholders and managers. But that's something that will get worked out. I'm hopeful that it will work itself out in the right way. But that crystal ball, you can eat glass a lot if you try to live by it. So I'm a little hesitant to say what I think will eventually happen, but that's my hope.
Well, Bill, I have a feeling that this is that you're a guest that we're going to need to have back. We only get to dent into your experiences here on this remote session, but we want to make sure that we get you back so we can pump you about some other issues as well. We wish you luck with your new assignment at Wilson Sonsini. We wish you luck with that. And Scott, that will conclude this edition of This Week in the Boardroom. We, again, have brought this to you from our annual Boardroom Summit, and it's been a lot of fun to do it in a different location. So we hope you find the show interesting, and we'll see you back in the studio next week. So we'll look forward to seeing you then.
Join us again next week for This Week in the Boardroom, brought to you by corporate board member and host NYSE Euronext, along with governance knowledge partner Paul Weiss and contributing partners National Investor Relations Institute and the Society of Corporate Secretaries and Governance Professionals.